Hello everyone, Derek Johnson with Tatango.com. Today we're talking about TCPA cases and the outcome of a TCPA case. This one's actually a TCPA text messaging case, so it's extremely important for our viewers. So this is John Nelson. He is a TCPA attorney, and today we're going to be talking about one specific case, which is Epps versus Earthfare. And if you're not familiar with the courts, Epps, the first part is the person versus Earthfare. Earthfare in the United States is kind of like a Whole Foods, a little smaller Whole Foods.
Yes, very small.
Okay, so they're selling groceries and stuff like that. Mm-hmm. So this person, Epps, that's their last name, right?
That's the plaintiff in this case, correct.
What do they complain? What was the issue that they had with Earthfare? Earthfare sounds like a great little shop.
Sure. So I guess we'll go with the short answer first, or what the complaint said, that would at first make you think this is bad, but really it isn't. The plaintiff was alleging that she had at one point consented to receive text messages for coupons, other marketing materials.
So she opted in.
She opted in.
Okay.
She claimed that she had texted back to the company revoking her consent to receive any further messages, opting out.
Yeah.
And claims that Earthfare's system did not recognize her opt-out, did not opt her out, and continued to send her more and more messages.
Okay, so that's super bad, right?
Super bad. That is your very typical TCPA violation right there.
If you opt out, and every single text message after that, anywhere from $500 to $1,500 per text message, and also as a brand, Earthfare, that's just not very nice to send your customers spam. Correct. Essentially.
Correct. Mm-hmm.
But this case was thrown out.
It was thrown out.
And Earthfare won. Mm-hmm. So what went on here?
So after the plaintiff, Epps, had filed her complaint, Earthfare had moved for a motion to dismiss.
Okay.
And essentially what that means is that based on the allegations made in the complaint and the evidence that the court has received up to this point, Earthfare was claiming that Epps had not produced, enough to for the court to plausibly conclude, that Earthfare had been liable for this issue, that they were actually in fault.
But aren't they at fault? Shouldn't they be?
They're not. And what they claimed was that in the plaintiff's complaint, she failed to plausibly allege that she had revoked her consent to be contacted.
Okay, so non-legal speak, what does that mean?
What that means is that she had not correctly opted out, such that she was still opted in, meaning that all of the messages she had continued to receive were legally allowed under the TCPA.
Because what was she was texting back stop or unsubscribe?
She was not. She was receiving each message she received from Earthfare contained at the end, something along the lines of text stop to stop.
Okay.
Very clear guidelines.
Yep.
What she was texting back, and we've seen this in a lot of other cases, were complete sentences. So some examples I have are, she would receive a message, she would respond back, "I would appreciate if we discontinue any further texts. Thank you, but I would like the text messages to stop. Can we make this happen? I'm simply asking for text to stop. I would appreciate that. Thanks."
So anything but stop, unsubscribe, quit.
She was being polite.
Yeah.
She was being polite.
But a little circumvent.
She wasn't following those
instructions.
Clear guidelines.
Okay.
And what the Earthfare was alleging was that she had opted out in an unreasonable manner.
She had attempted to opt out.
She had attempted to opt out in an unreasonable manner.
In the lawsuit, did she actually give Earthfare the messages that she was trying to text in?
She did.
Okay, so she essentially gave them...
She did. She and you will see this in a lot of professional plaintiffs' cases. They will keep a caller log of every message that they receive from the brand, because they want to make sure they're getting their $500 per message.
Per message.
And essentially what these messages were showing was that, contrary to Earthfare's text that clearly asked, "Please stop to stop," she was not doing this. And then what the brand had alleged was that, under the TCPA, marketers and brands and callers are only required to opt out those people who opt out reasonably.
Okay.
And what it claimed was that these complete sentences, were not a reasonable manner to opt out when she clearly knew, there were easy to follow instructions on how to opt out. And this case, the district court portion of this, it was an appeal, was decided before actually a major TCPA case came out of the DC Circuit, ACA International. And what a lot of cases have been signaling, and what the DC Circuit signaled, was that, we understand that brands are required to honor reasonable opt-outs.
Yeah.
But they are not required to honor all opt-outs.
Okay.
There are certain opt-outs that we are going to, possibly infer as unreasonable. And this can very much be the case where the consumer does not follow easy-to-follow opt-out instructions. And essentially, this is what Earthfare was arguing here, that Epps had been presented with a very clear, easy-follow way to opt out. Mm-hmm. Text stop to stop.
And that's, the carriers require that, the CTI requires it. Any consumer, if you are on a text message, marketing list, it is the best way to opt out.
It is.
She just did everything except that, it seems like.
Correct.
Okay.
And what the court ultimately concluded was that her method of opting out was unreasonable. And in making this conclusion, they really relied on two, I guess, key facts. The first was that she had received very clear instructions on how to opt out.
At the bottom of the text message.
At the bottom of every text message. 38 text messages, all saying text stop to stop.
So that's a great thing, because the CTIA, the carriers, kind of waver on that specific. They say it has to be in there on I think a monthly basis or something. At Tatango, we're always like, it's best if you have the characters, put it in there. Mm-hmm. Because when these type of things happen, it makes it such an easier argument when you're like looking at the text message and you're like, it says text stop to stop and you're not doing it.
Right.
But if you don't have that in there, it's a little more kind of gray. You got to argue that they should have known how to do it.
It is. And certainly, and all cases are different, but I would venture a guess that if that hadn't been in there on every text message, I don't know if the court would have gotten rid of this case as quickly as it did.
Yeah.
It may have let it go on a little while longer to kind of draw out what is reasonable, what is unreasonable.
Because again, these judges don't live and breathe text message marketing every day. These judges are just regular judges. So they might not even know that you can reply stop to a text message.
Sure. Mm-hmm.
So it is very kind of scary. So yeah. I do recommend most brands, either they do it in every message or they do it kind of on a consistent basis, just to make sure the customer, number one, make sure the customer, because the TCPA is one thing, but also if the customer just doesn't want to be part of the SMS list and they just really don't know how to opt out, you don't want that person on your list, even if they're not going to sue you. It's just a bad experience. Mm-hmm. So having those instructions all the time where they're like, oh, I can always opt out. This is a great experience. And when I want to opt out, I can. Mm-hmm. So it's kind of like, yes, you have the law side, but then also you have just kind of respecting your customers, relationship with them. Mm-hmm. So that's interesting.
Mm-hmm. And so you are very much correct. And we also recommend that you include this language, because it will protect you just generally. It'll also protect you from professional TCPA plaintiffs. And getting back to the court's conclusion, this was another kind of fact and area where they wanted to conclude that her opt-out was unreasonable. She was most certainly a professional plaintiff, because what they had found and what Earthfare had presented were other cases where Epps specifically had been doing the same thing to other brands. Opting in, sending back these long statements rather than simply replying stop, and then suing them.
So professional plaintiff is somebody that understands the law or thinks they understand the law, and they're essentially kind of going after companies for either gray areas or actually they are violating the law.
Correct. Yeah.
They do this for a living.
Yes. They're trying to, and the court used these words, manufacture litigation.
Okay.
And that's certainly what she was doing here. She had texted. She was a resident of California. Had texted Earthfare, which I'm not sure where they operate, but I remember from the opinion noting that it was a chain 2,000 miles away from where she lived.
She's just looking for
didn't
SMS.
operate online, wasn't near her or anything.
Yeah.
The facts were stacked up against her from the beginning, but really I think what helped Earthfare get out of this at such an early stage was that they had constantly told her, text stop to stop.
One thing I found interesting is you can always use these professional plaintiffs to almost help your brand. One thing I heard you say is they kept the plaintiff, the person, the consumer, kept meticulous records of every single text message. Mm-hmm. I know brands, not that use Tatango, but other brands that they have very limited records. So when...
Never a good idea.
Yeah, when they look up a phone number, they know when they opted in, but they don't know every single message they've ever sent that person, or if they've switched short codes, they don't have both sets of records. It seems like, thankfully this consumer brought the records to the court, but it could have been the other way where the brand would have had to show every single message and that it had stop in it and that she replied with all these crazy kind of statements. Correct. It just shows that brands need to keep every, not just the mass message, every inbound, outbound from every single phone number from really the start of their SMS campaign.
Mm-hmm. It's very important because when we get to TCPA cases and a consumer is alleging they revoked their consent or never provided you with your consent, you as a brand can't just come in and say, oh no, they consented.
Yeah, you have to prove it.
You have to prove it. That's your burden to prove. And it's your burden to prove that each and every one of those messages was a consent given message. So the more records you have, the more you keep, the better off you are.
Yeah.
The quicker you can dispense with these cases.
Yeah. Because really, data at the end of the day doesn't lie most of the time.
No, yes.
One thing I think that is good to know, because people watch these videos, and then some of them unfortunately do get attacked by these professional plaintiffs. This happened not at this court case, wasn't at the Supreme Court level.
No, it was not. So originally it was a district court case in which the district court had granted Earthfare's motion to dismiss, which gets rid of the case, terminates it there. Plaintiffs, of course, from final decisions like this can appeal to the next level. Now, this case, I believe, was in the Central District of California, federal court. It was one of the federal district courts in California. That's in the Ninth Circuit.
Okay.
So if the plaintiff wants to appeal, that's where she must appeal. She cannot appeal directly to the Supreme Court. And that's what she did here. But in a very short one-page opinion, the Ninth Circuit reviewed the facts that were presented to that district court judge, the complaint, everything that had been exchanged, and pretty immediately concluded that, based on the facts, the judge had interpreted, or made the correct ruling.
So, and I guess what I'm trying to get at is this: if you're watching this video and you do receive, let's say, a threat of a lawsuit, and you're maybe in New York or Florida or something, this video in this case does not mean you can you're like, oh, this has already been resolved. There's already case law, it has to go to the highest court to go down.
And this particularly is extremely case specific.
Okay.
You can use the tactics that this defendant used. You can adopt them from other cases. You can cite to those cases in the event you are sued. But it's very important to know that each case's results are specific to that case.
So this doesn't protect SMS marketers from this type of thing going forward.
It does not. It's a good sign.
Yeah.
It shows that courts are finally catching up with what we've been saying, that professional plaintiffs are trying to get out of professional plaintiffs are trying to manufacture litigation, get around the rules, and that there should be ways of opting out that, courts find unreasonable because they simply aren't something that a normal person would do if they're trying to stop these messages.
But this is still a threat. If you do see these kind of messages being sent into your system, that's usually the best time to start engaging with an attorney, just kind of preemptively. Mm-hmm. And it's not something where it's like, oh, no, it's okay. Earthfare has figured it out.
Not at all. No,
Okay.
that is specific to that case only.
Yeah.
In the event that's happening to you, you should not rely on this opinion or this outcome as protecting you in any sort of way. That plaintiff can still sue you, and if you have the wrong judge and the same facts, they could still reach the other way. But it's important to engage an attorney, a TCPA attorney, if you're noticing these messages or if you
And it's
receive
pretty
some
obvious.
sort of letter.
We've seen them before. It's
It
pretty
is.
obvious because it's not stop and quit, unsubscribe. It's these extremely long sentences
Or
of
poems sometimes.
Yeah, it goes against everything a normal person would most likely do to try to opt out.
It does. And if you see that, you can almost guarantee the person is likely a professional plaintiff, and you can expect some sort of lawsuit
Yeah.
reasonably soon.
And that's why it's so important. Keep the message history, everything. Every single message in and out.
Mm-hmm.
Because if they're texting stuff in and you only keep messages that go out, you cannot go to your attorney and discuss the whole message flow.
Correct.
It makes it very hard, and then it really puts things in kind of precarious situation. If you can, put in the instructions to opt out in the message. Nice thing about MMS is it gives you a ton of characters, so you always can put it in there. SMS is 160 characters, so the CTIA carriers, they usually say try to, on a frequent basis, put it in. I see some clients, they'll have a big message and they can't fit it in, but then the next message they put it in. You want to have it so that a judge that has no knowledge about text message marketing looks at it and goes, well, that seems pretty reasonable. It's every other one. It's everyone. You don't want to make this so hard where they're like, well, on November 5th, you said to stop, replying one message. And then next year you said, I as a judge would look at that and go, that doesn't seem that's not the best instructions you provided. So
And what we've recommended to our clients and others is that, follow the CTI guidelines. The CTI guidelines aren't part of the TCPA law. Following them does not mean you aren't violating the law. But if you're following those guidelines, chances are you are acting reasonably, and you can use that as evidence in the event that you are sued.
That's great. Okay, that is another TCPA case review. This was Epps versus Earthfare, and it got thrown out. It got thrown out twice, essentially, right?
Thrown out and then affirmed. So
Affirmed. Okay.
should be gone for good now.
Okay, that's always good. But this person is a professional plaintiff. They've been known to do this in the past. So it is, again, the advice we're giving you, this is not something that's been resolved. This is something I think that people need to be aware of. And luckily, we've been talking to somebody that is very aware of it, who is a TCPA attorney, John Nelson. My name is Derek Johnson with Tatango.com. And again, we are answering not only questions on TCPA compliance and how brands should be, dealing with all these issues, but looking at actual court cases, TCPA court cases, and figuring out how they impact your brand.